I'd like to welcome everybody today to this IANA webinar called Family First Coronavirus Response Act, Other Critical COVID-19 Employment Issues, and Intermodal. I'd really like to thank everybody for taking the time to be with us today. I know that it's a challenging environment for everybody, both socially, familial-wise, and business-wise. Without further ado, I'd like to welcome our speaker today. We kind of went for the cream of the crop and went to Margo Wolf O'Donnell, who is the co-chair of the Labor and Employment Practice Group at Benesch, Friedlander, Coplan Aronoff, both an IANA member and our counsel. And she is up to date as anybody can be on a lot of the issues related to this challenging time. So without further ado, I'm going to kick it over to Margo and let's get started.
Good afternoon. As Hal said, I am an employment lawyer. I've been practicing in the area of employment law for more than 25 years. And I have to say the last few weeks have been incredibly challenging as the law emerges and changes in several key areas that I think will be of interest to you, you may know about. What's also so different is that there are regulations and guidelines coming out from the government almost on a daily basis. Some of what I'm going to tell you about today has become more settled in terms of the law, but because this area of the law is changing so rapidly, what I'm telling you today doesn't necessarily constitute legal advice. So if you have a real issue with some things that I'm mentioning today, you can reach out to me directly for legal advice or seek advice from an attorney. What I want to give you today is the information you need in order to address some of these really tough issues as an initial matter, and also so that you can spot these issues in your workplace. So first I'm going to cover the Families First Coronavirus Response Act, which is new as of the end of March, and the leave requirements and that it provides for if you have 500 or fewer employees. The EEOC has issued pandemic guidance, which really changes how you are allowed to treat your employees, especially under the Americans with Disabilities Act. Those guidelines and requirements have been loosened a lot, so I'll tell you some about that. I'll talk some, and this seems to be the issue of the week, unfortunately, how to handle furloughs and temporary layoffs. And I'll talk some about permanent layoffs and also notifications that are required with some of these layoffs when there's certain requirements that are met that triggers these laws, WARN laws, and also many WARN acts. And then I'll talk some about reducing hours and compensation. It's not as simple as it might appear at first. So without further ado, let's get started. The Families First Coronavirus Response Act. This is new as of March, and this is one of the laws where the guidelines and requirements and what you can and can't do has been a bit of a moving target for the past few weeks. And because of this, it's not going to be enforced by the Department of Labor, and there won't be any penalties for non-compliance until about April 17th. So you have this time to show, if you have fewer than 500 employees, that you're making an attempt to get up and running and comply, but there won't be any penalties for non-compliance for a little bit longer now. And it can be somewhat confusing, so I'm going to try to explain it to the best of my ability today. But if you have any questions regarding a specific issue, let me know. It generally just provides paid leave benefits in certain circumstances. If employees cannot work due to reasons related specifically to this pandemic. And as I said, it's required for employers with less than 500 employees. And what's important, there's been some new guidance that came out, and the number of employees you have is determined by the date the leave is requested. So while you may be laying off employees or hiring employees, if you're less than 500 or more than 500 on the date requested, that's the date that's relevant. Also, the paid leave must be taken between April 1st and December 31st. And I'll talk some more about this. The new guidance and regulations say that you have to have written documentation and supporting documentation to get the payroll tax credit. And you really only need to receive advance notice for the leave that's for caring for a child. So let's just kind of break this down, because I know that's a lot to take in. So let's first go to the 500 employee threshold determination. Does this even apply to you at all? And I've gotten some questions, do my employees all have to be in the US to be counted? The answer to that is yes. Does it have to, and this gets a little tricky now too, and sometimes you need to think about your workforce, on a case-by-case basis. It includes temporary employees who may be deemed jointly employed. That means that these are temporary employees that you control. If they're true independent contractors or they're on a layoff, they won't be included in that number. But you need to be very careful if you're kind of on the edge of 500, less than 500 or more than 500, and think carefully about whether or not this applies to you. I've had to go through this consideration with a lot of my clients. Can they get over that 500 employee threshold because they're considered one employer under the joint employer test under the Fair Labor Standards Act? That means, do you control more than 500 employees? And then do you have more than 500 employees under common management as well? That's relevant too. And thinking about whether or not your operations are related, whether there's centralized control of labor relationship, and whether there's a degree of common ownership or financial control between the two entities. So if you treat two entities together for purposes of FMLA, chances are if they aggregated together, those employees go over the 500 employee threshold, then you probably are not subject to this act. But I would think carefully about that determination. So then what does it provide? It provides paid sick leave only up to 80 hours for an employee who's not able to work or telework at full pay because they're quarantined. Now, this trigger of the quarantine, I've gotten a lot of questions about whether or not the shutdown orders qualify as a quarantine, and are they a federal, state, or local government order or the advice of a healthcare provider? So the guidance and the regulations seem to go back and forth on this. Certainly, if there's a shutdown order and your employees can still work because you're an essential business or they can telework, then it's not triggered by that. But if your employees cannot work because there's some issue because of the shutdown order, then there could be a trigger of this sick leave requirement. So you need to think carefully and look to the guidance and the regulations if that's the basis for the request for the sick leave. Certainly, if someone is experiencing COVID-19 symptoms or the time they're taking to seek a medical diagnosis, that qualifies for sick leave. I've gotten the question of, what if someone wants to take this sick leave, they go and take the COVID-19 test, and then they test negative? That time that they took to take the test still qualifies for this sick leave, even if it's negative. Okay, going back. And then there's some provisions for 2/3 pay, and there are limits on this, as you see in the slide. And this is if you can't work because you need to take care of someone who is subject to a quarantine, and then if you need to take care of a child. And the guidance kind of goes back and forth on this. Generally, it's for children under 18. And if it's a child who's over 18, that would be because they have a disability. That means they can't take care of themselves. And it's only when their child care provider isn't able to come or the school is closed for reasons related to COVID-19. But right now it's pretty clear that virtually all schools are closed, and it's virtually impossible or not really compliant with these orders to have child care providers come into your home. So what you need to show for that is somewhat minimal. And also I've gotten the question of, what is a child? That's someone, can be kind of broad, but there has to be some sort of proof that this is a child that you're responsible for taking care of under the law. So that could even be a grandchild that you have custody of, but there has to be some sort of evidence that this is a child that you're responsible for, not like the next door neighbor's child, unless you've somehow gotten custody of that child. And also, there's just sort of a catch-all here about a substantially similar condition. But again, you need to make sure that it's related to COVID-19. Then there's also an expanded FMLA leave, and this gets to be somewhat complicated. The guidance and the regulations make clear, though, that you're entitled to this leave if an individual or an employee has already taken FMLA leave, even if that FMLA leave was unpaid and prior to this law, that eats into the time that they're allowed for this expanded FMLA leave. So let's say someone took FMLA leave earlier this year for a serious health condition, took up 5 weeks of that leave. That goes into the 10 weeks that's allowable here. And also the provisions for allowance for expanded FMLA leave are broader here. To be an individual who qualifies for this expanded leave, you only have to work for 30 days. Paid sick leave and the expanded FMLA leave are a little different. As I said before, the expanded FMLA is not in addition to the regular FMLA. It is within that time frame. But the paid sick leave is different because that is in addition to any other paid leave already offered. So let's say your employee has PTO under your policy, and also there may be sick leave requirements under state or local law. This is in addition to that. So they get the additional 2 weeks that's paid. And the expanded FMLA leave, or the leave for caring for a child, can be taken on an intermittent basis. Certainly if someone's experiencing COVID-19 symptoms, they shouldn't be coming into work on an intermittent basis or any basis at all. Hopefully you all know that there's a poster that's been issued by the DOL that you should put up in your workplace if you're a covered employer. And as I mentioned before, if your employees cannot work because of some aspect of the shutdown order, you should think about whether or not that qualifies. There are also some exceptions for small employers of 50 employees or less. If this would place an undue burden on your business, you can work to gather supporting documentation to accept yourself from the requirements of this act. The helpful thing about the FFCRA is there are tax credits. Covered employers can qualify for dollar reimbursement through these tax credits for qualifying wages that are paid here, and those are paid for under the act for a qualifying reason. So that's why it's so important to make sure that you've gotten written documentation at some point as to which of these buckets it falls under and what was the triggering requirement that allows for the sick leave or the expanded FMLA. It also can extend to amounts paid or incurred to maintain health insurance coverage. So I think the best tips with respect to the FFCRA is to make sure that you carefully consider whether or not you're a covered employer. If you're 50 employees or less and this would place an undue hardship on you, think about working to gather documentation so that you fall within the exception, and then make sure that there's a specific method in place for gathering supporting documentation. I mean, it doesn't have to go to the nth degree, but if there is a school closure, I would have them, send you information or even like an email from the school that reflects this. I've been preparing forms for my clients to use where the employees clearly check a box to show what they qualified for and why. So use of those sorts of forms, I think, are helpful. There isn't a set form like with the FMLA. So if you're going to create one yourself, you should make sure that it follows the letter of the law. Moving on now to the EEOC pandemic guidance. And what does this mean? The EEOC is the Equal Employment Opportunity Commission, and they are the administrative body that has purview over laws such as like gender discrimination laws, age discrimination, but also the Americans with Disabilities Act. So they're charged with enforcing that law. And they very specifically stated that generally if someone exhibits a disability, there's certain things you can and can't do in the workplace. But because the COVID-19 has been labeled as a pandemic, there are certain requirements that have been loosened in order for you to make your workplace safer that are just in place now. And when And so I would carefully think about, this I think will be the case for many weeks, if not months to come. But should the label of a pandemic be removed, then the answers to these questions will change. So the first one is, can an employer send an employee home if they display influenza-like symptoms during a pandemic? The answer to this is yes. And a lot of this question and answer, this was developed in 2009 during the swine flu epidemic. So that's why the questions and answers are influenza focused, but these apply to COVID-19 in the same manner. The EEOC has been really specific about this. So if you have an employee who's displaying COVID-19 symptoms, send them home. If you see them coughing or they're expressing that they have fever, chills, shortness of breath, or a sore throat, you can send them home immediately. And then I've gotten a lot of questions of, what can I ask my employees if they say they're not feeling well or say they've called in sick? Well, you can talk to them and ask them what their symptoms are to see if you think that they are COVID-19 related. And this is a big one. This would be a big no-no before the issuance of the WHO's declaration that the COVID-19 is a pandemic. Can employers take employees' temperatures to determine when they have a fever? Before a month ago, the answer to this would be emphatically no, definitely not. But now you can take your employees' temperatures when they enter work or when they report to work. But you need to make sure if you do so that you maintain medical information on a confidential basis. But many of my clients have said, if I do this, there may not be much benefit to this because even if my employee doesn't have the temperature, they could still have COVID-19. So something to think about. I haven't seen this done on as much of a basis as I would have expected, but just something to think about. Can you, and this is becoming less and less relevant since we all haven't really been traveling too much lately, but I imagine some of your employees are traveling for their jobs. Can employers ask employees about their exposure during travel? Yes, absolutely. And that's during the course of employment for you or outside of employment as well. You could ask them, whether or not they feel they've been exposed to COVID-19 or to people who were exhibiting those symptoms. So basically, with respect to issues relating to COVID-19, you're a lot more free now to ask about what someone's experiencing when they call in sick than you were in the past in order to protect yourselves and your workplace. So let's say now that you've thought about the FFCRA and you've taken the steps to protect your workplace. And though I've mentioned the EEOC pandemic guidance, that doesn't go into OSHA guidance, which I'm not going to cover in detail today. But OSHA and the CDC have come out with detailed guidance about how to keep the workplace safe. So if you are having employees come into the workplace, you should make sure you're up to date regarding that guidance and think carefully about making sure that you're in compliance. Because we've seen the first lawsuit here in Illinois. I'm not sure if you've heard about the lawsuit against Walmart brought because of the death of one of the employees. So the defense to these types of cases, while outside the scope of my expertise, since I'm an employment lawyer, but it's one more reason to make sure that you're ensuring that your workplace or where your employees are working is as safe as possible. And you may have to employ some of these tools that the EEOC says you can use now, which you haven't been able to do so in the past. But still, in addition to those, make sure you're up to date as to what OSHA and the CDC recommend, which is which would be a whole nother presentation, but you need to make sure that you're up to date on that. So let's say you have your employees, some of them teleworking, some of them at work if you're an essential business with respect to these mini shutdown orders. But you still need to think about how to keep your workplace solvent. And what I'm seeing increasingly is my clients are turning to permanent layoffs, which I'll get to next, but also they're using the tool of a furlough or a temporary layoff to try and get them past what's going on now financially. And so what is a furlough or a temporary layoff? Technically, it's when you tell your employees they have time off without pay. The good thing about it is that they can remain on the payroll and they still have access to their benefits. Another good thing about it is there is an expectation, although not a requirement, that they return to work. So it can help company morale if these employees are told they're only laid off on a temporary basis rather than a permanent basis. It also enables you to bring back your workforce, hopefully quickly and expeditiously when this pandemic lifts. It enables you also to provide notice of unemployment benefits. And when you're going to do a furlough, I've done a couple of these already, even this morning, make sure that you provide notice, and different states have different notice requirements. But the important one is that you make sure that you tell your employees that they can't work during the furlough, and I'll cover more later as to why that's important. If you know how long the furlough is, you should provide the length of it. Oftentimes I'm seeing notifications that say less than 6 months, and I'll reference later why that time frame of less than 6 months is so important, that you're going to reassess as the furlough proceeds, that you can't, and this will make sure that you're not obligated to stick to that length of time. And make sure you let the employees know how they can reach out to you, and also ask them if they will let you know if they are exposed to COVID-19 or should they have a positive COVID-19 diagnosis. And also, unfortunately and terribly, what I'm receiving now is also questions about how to handle it if an employee has a death due to COVID-19. You can ask for, that certainly should be, you should be notified of that as well. So how to handle a furlough and temporary layoff is a little bit different for hourly employees than for salaried employees. So non-exempt employees who are generally, hourly and not paid a salary, make sure that if you're going to do a furlough or temporary layoff, that some states may have different notice requirements, and some states may give show-up pay. So if you don't give adequate notice, and this is in California especially, if you show up, if those individuals show up to work and don't get the notice, you may have to pay them for a part of the day. Make sure that if an employee is on paid sick leave or other paid leave before the layoff occurred, think about how to handle that. Employees aren't entitled to FCRA, sick pay, or pay for leave while they're on a layoff or a furlough. But if they're already on that paid leave, you should think about whether or not they should be furloughed at this time or after it concludes. Also, I would think about the predictive scheduling laws some states have and whether or not they might apply. That would indicate how much notice you might have to give of a furlough or a temporary layoff. Exempt employees, you need to be especially careful of, because if they work for any amount of time, even 1 minute in any particular week, they generally must be paid a full salary for that week or they lose their exempt status. So that's why it's so important to tell exempt employees not to perform any work during a furlough and that they're not authorized to perform that work. And sometimes it's a good idea to tell them that if they do perform work without authorization, they might be subject to discipline. And the notice can state whether or not the individuals can use paid leave or vacation while they're on the layoff. Some employers are allowing this and some are not. And the reason also why temporary layoff can be easier for an employer to administer is because with a permanent layoff, there are certain payout requirements that are triggered under many state wage laws. You would generally be required to pay out accrued vacation, and other amounts could be required if there is a permanent layoff. So I would think about whether or not that would make sense for you if that's what you're thinking about doing, and what state you're in, and how and what those laws are in that particular jurisdiction. For instance, in Illinois, where I work, if there's a temporary layoff, employers are not required to pay out accrued vacation, but if it is a permanent layoff, they are. So you should be mindful of this too, should your furlough or temporary layoff turn into a permanent one, what requirements are to pay out at the conclusion of the employment period at the time of the permanent layoff. Also, you should think carefully about the WARN Act, the Federal WARN Act. A temporary layoff or a furlough of less than 6 months doesn't trigger the notice requirements. But if it becomes apparent that the temporary layoff or the furlough may be more than 6 months and you meet the other requirements of WARN, you may be required to provide notice. But I would just be cognizant of that law and the requirements. There may be an exception for unforeseen business circumstances. The issue now is that the business circumstances at this point in time seem to be becoming more and more foreseeable. So to the extent what's foreseeable now and what's foreseeable a few months from now might be different for you, I would think about what specifically in your business might change between now and then to make the temporary layoff make it last more than 6 months. If there are enough employees, if you have enough employees at your business and there are enough employees affected by the furlough to trigger WARN, you should also be aware that some states have mini WARN acts. So if you have employees in many states, you should think carefully about that. And they often have requirements that fewer employees have to be impacted than the federal WARN Act. If you've decided not to furlough or lay off employees, and you decide that, or maybe you're furloughing some of your employees, you're laying off others on a permanent basis, and you want to reduce the hours and compensation for other employees, you need to think carefully about that, especially versus hourly employees versus salary employees. I've gotten a lot of questions about what notices are required. And what I mentioned before in terms of predictive scheduling and show-up laws are at play here as well. If you're going to change the actual hours that your employee works, I would imagine that you do this on a regular basis. You're generally free to do so, other than with respect to those predictive scheduling laws, when you have to give their schedules farther in advance. But I imagine that this is something that you do with more frequency. So if you're going to cut hours, that might be for hourly employees, that might be an easy fix to implement immediately if you haven't done so already. But if you're going to change how much you pay these hourly employees per hour, there could be notice requirements for many states and localities. For instance, in Illinois and Michigan, I know because I just dealt with this today, that notice just needs to be reasonable and needs to occur at some point before the change in the hours actually occurs. In certain jurisdictions, this notice of the change in compensation has to be in writing. So we would think about that and how to draft that form. Also, you need to be careful if you're reducing the compensation of exempt employees. That needs to be done on a prospective basis to keep the exemption. And generally, it can't be done as frequently as you can for hourly employees. You can't change their salary levels from week to week or day to day. You need to think about doing this maybe once based on these financial conditions. And if you have to do it with more frequency than that, you definitely may be risking the exemption. They may go from salary to hourly under the law. Also, you need to make sure that they are paid at least $684 per week, which right now is the salary basis. And if they go under that amount, you need to think about the fact that they now may become hourly and you may be required to pay overtime. I would think carefully also about the notice that you're going to provide exempt employees. Make sure that it's crafted so that the exemption can stay, and it has to be a bit different than the hourly one. That this is, because of you need to be very specific about why this is being done because of the financial issues that the company has faced during this extraordinary time relating to COVID-19. So while you have a lot of methods of reducing your workforce, reducing the pay of your workforce, and laying people off, you need to be careful that you're complying with the law when you do so. Also, make sure that if any of the employees you're laying off or even putting on furlough have employment agreements, you need to make sure that what you're doing complies with those agreements, whether or not there are force majeure clauses in those agreements. And if you don't have them in your employment agreements now, I think now's the time to put them in so that you can terminate employees who are subject to that agreement because of any extraordinary events that occur. So I would think that probably in the near future, we're going to see an uptick in claims relating to wage and hour issues and with respect to these layoffs. If the proper notice isn't given and there isn't compliance with the law, often the notice requirements, WARN Act claims are quite easy to bring. And I would think that employees that are out of work will have time on their hands to think about bringing these claims as well. Also, if you're providing these notices, think about giving your employees sufficient notice of unemployment. There's increased unemployment now available under the CARES Act and under state law. So that's especially important for your employees that you're laying off on a temporary basis. In some instances, in many instances, employees actually may make more money if they're laid off on a temporary basis than if they stayed employed by you. I would think about the numbers there and what makes sense for your workforce and what makes sense for you as well. So now I'm happy to answer any questions you might have on any of these topics or anything else related to employment and COVID-19.
Thank you so much, Margo. I really appreciate it. That was a lot of great information. I think that we all can appreciate the challenges that you're under to try to keep informed and keep the information current as it changes, as you pointed out earlier on, day to day. We've got a couple of questions coming in. I think one of the questions that we've got is from an operator that works in multiple regions. And their question is, would you suggest that they talk to counsel in each of the regions that they operate, particularly the states that they operate, or would a single attorney be able to help them manage their approach to this if they're operating in multiple jurisdictions?
I think that if they have an attorney who can answer questions relating to multiple jurisdictions, it might be easier to just deal with fewer attorneys on these issues. For instance, many of my clients operate in all 50 states. And so, Benesch, my firm, has the resources to be able to service employers in all 50 states or in a few states. I mean, we're aware of all the issues that arise in those states. So I guess it just depends. They certainly should be mindful if you have an attorney in just one location of what's happening in each of the jurisdictions where you are. So make sure you tell your attorney where your employees are and that, each of these issues that I've hit on, can implicate state and local laws, even the Families First Coronavirus Response Act. Even though that's a federal law, there's some interplay there with state and local sick leave laws. So you need to make sure that your lawyer knows where your employees are. And if there's a specific issue with a specific employee, they need to know where that employee is too.
Here's a question, and it's sort of about reviewing your agreements, reviewing your contracts in light of everything that has gone on with COVID-19. But the question is, are there like 4 or 5 things that folks should take a look at to get their house in order if perhaps they're, I don't want to say they've been sloppy, but I think the questioner is saying, if there are 4 or 5 things that we should kind of go look at as the major trouble points they might have problems with for you?
Sure. I would make sure, to the extent you have employment agreements, there's a provision that you can terminate employment. I mean, at will employment is the best for an employer, and most states allow for at will employment, that your agreements specify that. And if not, if there's a term of employment, that there's some sort of out based on an extraordinary event. And that's really what I mean by a force majeure clause. I know that non-competes even still can be at issue now. I would think about whether or not your non-competes are enforceable under the law. Also, your PTO, whether or not that policy enables you to allow for furloughed employees to use PTO or not use PTO. I would make sure you're up to date on what your PTO policies say. I would make sure you're up to date on what you're required to do under the state and local sick leave laws. And also that this is very important, that if people are coming to work or working with equipment or transportation modalities, that you're doing whatever you're required to do to keep your employees safe in order to protect against any of these claims we're sure to have. This is probably more than 4. And then I would make sure that if you're going to have layoffs and you're going to reduce comp, that you're following the proper procedures that I was referencing. Because even a simple thing like notice, it would only take me like maybe 20 minutes to prepare. But if you fail to do so, you could have a class action that you could be hit with the other side's attorney's fees, and it could cost you millions of dollars. So a little bit of preparation now could prevent a lot of pain later.
It certainly sounds like it. It's sort of a question/comment, but one of the attendees is saying that they've made some pretty significant changes to their operating directives that they have for their independent contractors. So when they're hauling loads for them, they ask them to, in addition to the standard things of wearing their safety vest when they're out of their power unit and things like that, they've made some additional requests of those independent contractors, like wearing gloves when possible, wearing masks when possible, frequently washing or sanitizing their hands, making use of apps that terminal operators provide them when possible to minimize interactions with either terminal employees or those kiosks that are sort of becoming ubiquitous at unmanned gates to get in and out of terminals. So I guess it's sort of a statement, but it's also a question. Do you foresee any problems with something like that?
Yeah, and I think that the problems could be whether or not you're deemed to be a joint employer with those independent contractors, and to the extent that you have any obligation for the safety of those independent contractors, which you probably do under, pursuant to any agreement that you have, and also there's any sort of determination of being a joint employer. So I would work with your independent contractors on safety issues. I don't see any problem about I guess the problem about controlling the safety of your independent contractors' work, I guess that might be one factor later that could go under the common law, support a determination of joint employer status. But I think right now you should be focused on safety first. But if there's, the answer may change depending on the specific situation or the agreement in place. But those are the things to think about.
Yeah, no, that's really a good point. And I think, what we're seeing again and again is one of the watchwords needs to be people need to be flexible and reassess on a kind of an ongoing basis, and not just say, well, this is how it is and we're going to do this from here on out. They do need to be able to have some flexibility and address their policies on an ongoing basis to adapt to what's really an uncontrollable and unforeseen critical situation for everybody. This one sort of relates, for a lot of folks, their staff is now kind of moved to remote working. Are there any things that they should look for in terms of transitioning what would have been their office work policies into now a fully remote staff that they didn't really get to plan for? Are there things that they should watch out for, things that they should be mindful of?
Well, I think if this is probably maybe one of the top issues, if they don't have a remote work policy, they should think carefully about having one. They need to pay careful attention to hourly workers who are working remotely and how they're tracking time. I know it's difficult, but now we have more hourly workers than ever working remotely, whether or not they're getting, the breaks and not exceeding the hours that are allowable under state or federal law, and how to handle equipment issues, also data security issues. I know that's something my firm is addressing as well. So, but I would think about, if you don't have specific policies for remote work, getting those in place now.
Great advice. Well, I think going to about do it for our questions. I'd like to first thank you, Margo, for taking the time to put together this great presentation for us, covering a lot of stuff that is critically important. And for many folks, I think everybody can appreciate the fact that you're learning as you go with the changing laws that keep coming out, either from the federal government or from state and local authorities. So we really appreciate you kind of helping walk us through the high points of things that we need to be paying attention to as folks doing business in the intermodal supply chain. And I'd also like to thank everybody for joining us today. We know that you've got a lot going on. We know that you're extremely busy trying to make the best of a very challenging situation. It's very fluid. And so we appreciate you making the time to spend some time with us. And with that, I would like to ask that everybody be patient with one another, be safe, and be mindful, and we will all get through this together.